Can Ripple beat the SEC? When will Ripple present new arguments in its defense? How much will XRP cost after the trial ends? We will answer these questions in today's video. In the meantime, subscribe to the channel and we're getting started. Publicity-hungry Twitter lawyer John Deaton recently boasted about getting the U.S. Securities and Exchange Commission, SEC, to declare on record that LBRY's LBC token is not a security. Many saw this as a hint that the big bad SEC had been put in its place for overreaching, and that Ripple, another business fighting the U.S. regulator over an alleged unlawful securities offering, may win. Deaton exaggerates, and XRP in any future crypto product will be unaffected. The SEC defeated LBRY months ago. A U.S. federal court concluded that LBRY's LBC token sale was an unregistered securities offering and unlawful. The SEC never called LBC a security. As Deaton notes, Howey cases are about whether the item was offered as an investment contract, not whether it was a security. Investment contracts are securities. LBRY and Ripple are SEC cases. Given that LBC's original sale was unlawful, may bag holders resell tokens on the secondary market. The SEC's proposed phrasing might ban LBRY's direct and secondary sales. The SEC seems unwilling to agree that any secondary market sale would not violate securities laws in court argument. Deaton entered. Naomi Rockwell, a crypto journalist, possesses 261,500 LBC tokens from the secondary market. No LBRY tokens were bought. As an amicus curiae, she asked the court if its LBC token ruling would restrict secondary market sale. Deaton represented her. If not, reject the SEC's wording. Deaton represented Rockwell in a remedies hearing last week. On his own program, Deaton pointed the judge to the widely distributed Lewis Cohen article, which examined 7 decades of securities case law and concluded that the asset underlying an investment contract has never been considered a security. Thus, any SEC order should not prevent LBC holders from selling tokens on the secondary market. Deaton claims he won many industry wins here. That's exaggerating. The SEC would have acknowledged that the pure situation of a wholly independent resale of tokens, the first selling of which was unlawful, is not a securities offering. The SEC never disagreed. Their legal documents confirm. The SEC has repeatedly said that the LBC token is not a security. Therefore, Deaton's on-record claim is meaningless. The SEC's hesitation to declare that no secondary sale constitutes a securities offering is justified. The LBRY case has always been about LBC token sales by LBRY, not secondary sale. The SEC may have submitted an unclear order, but as its documents show, it never intended to make any assertions regarding secondary sales as legality. The court asked the SEC about a simple transfer from one party to another, which the SEC properly recognized would not be a securities offering. However, this does not indicate that no secondary sale could ever be a securities offering, as Deaton claimed. Secondary sales may violate securities laws, transaction-type matters. The judgment does not affect the fact that LBRY's first offering was an unregistered securities transaction. That's why XRP is under fire, and the LBRY lawsuit won't impact Ripple's liabilities for its first XRP sale. Ripple officials pledged to develop secondary markets to boost the coin's price, which the SEC claims triggers the Howey test's expectation of profits depending on the actions of others prong. Fox Business's Eleanor Terrett says the SEC will make a huge announcement tomorrow. The case Ripple is fighting at the SEC is almost over. Attorney James K. Phelan says all the evidence has been presented, and the decision will be made by Judge Annalisa Torres. For thousands of XRP holders, attorney John E. Deaton has been representing their interests as a friend of the court, and he recently argued that an out-of-court settlement is unlikely before the court ruling. The lawyer had faith that the regulator would fight to the very end after the LBRY decision and the FTX crash. Thus, he believes a settlement will occur only after the court has stayed the trial and heard appeals. A lot has happened in the LBRY case since the lawyer made that forecast. Attorney for Naomi Rockwell claims that the judge ruled that secondary market sales of LBRY credits are not subject to his earlier ruling that such sales constitute securities. The lawyer claims that the SEC was forced to admit that the assets in the investment contract are not securities by the judge. Ripple's general counsel has likened the SEC's case to the Chinese spy balloon shot down by the U.S. military, and we're all waiting for the court to make a decision. And this is something that Tarot recommends. According to Bloomberg, the SEC is looking into the leading cryptocurrency exchange for selling unregistered securities to U.S. citizens. Unnamed sources claim that the investigation is wrapping up and that a resolution could be reached in the next few days. According to CoinMarketCap, $629 million was traded on Kraken during the past 24 hours, making it the third largest spot cryptocurrency exchange. It offers access to 221 unique digital currency options. It is unclear from the report which of these are considered securities by the U.S. market regulator. The reported SEC claims can be understood in light of the chair of the SEC's views on cryptocurrencies. If not Bitcoin, Gary Gensler considers most cryptocurrencies to be security. Earlier this year, the SEC filed charges against Gemini and Genesis Trading for allegedly offering and selling unregistered securities through Gemini's Earn program. Coinbase CEO Brian Armstrong tweeted on February 8 at 11 p.m. That he had heard rumors that the SEC would prohibit retail investors from staking cryptocurrency. According to Coinbase's CEO, if this is the case, it will hurt the country. Armstrong claims that running blockchains in conjunction with users enhances scalability, security, and carbon footprint. Armstrong echoes this sentiment, saying that staking can be dangerous. To prevent us technology from being stifled, Coinbase's CEO has once again called for clear crypto rules. Armstrong used the collapse of Fox to argue that the SEC's focus on enforcement alone forces businesses to relocate overseas. Through staking, users are rewarded for securing crypto assets, which are then used to verify blockchain transactions. With Cardano, you can stake liquid assets without having to keep them in a bank. Investments in cryptocurrencies fall under the purview of the Securities and Exchange Commission. Gensler claims that if Ethereum adopts POS, it will be considered a security. Cryptocurrency exchanges impose fees for staking. Coinbase had 12.8 of the 16 METH staked in January, making it the second most popular Ethereum network staking service. Therefore, prohibiting retail staking may be detrimental to the company's bottom line. Similarly, the SEC is investigating Coinbase for selling unregistered securities to U.S. customers. The SEC claims that 9 of Coinbase's cryptocurrencies are securities in its insider trading case against a former project manager and 2 others. Investors may move their funds to less censored decentralized services like Lido if the SEC bans retail crypto staking. The U.S. Securities and Exchange Commission (SEC) lawsuit against Ripple Labs is not the only battle the company is currently fighting. In fact, there's a court case that has been under trial for a longer period of time. The class action lawsuit filed by XRP investors against Ripple Labs and CEO Brad Garlinghouse, which has been pending since November 2018. The case, which is being heard in the U.S. state of California, is led by lead plaintiff Bradley Sostek, with 3 lawsuits, Zakinoff, O'Connor, and Greenwald. Consolidated into one, the plaintiffs accuse Ripple of selling XRP as an unregistered security and seek damages for losses suffered from the sale and alleged promises by Ripple. In addition, the plaintiffs are asking the court to also classify XRP as a security. Attorney John E. Deaton, who is already involved with a respective amicus brief in the Ripple vs. SEC and Elbree vs. SEC cases, is now getting involved in this case as well. As prominent criminal defense attorney James Phelan writes in a series of tweets, Deaton is filing an amicus brief in Zakinoff vs. Ripple. Phelan writes that the proposed class would include XRP holders around the world, including the 75,890 holders in the SEC case who have joined Ripple's arguments and disagree with the plaintiffs in Zakinoff, saying that XRP is not a security. Moreover, the proposed class action is not limited to direct sales by Ripple, but extends to all sales of XRP, including secondary sales and international sales in countries where the token has already been classified as not a security. Deaton argues in his motion that the court should not certify the class because of these conflicts and because there are only a small number of holders who claim that XRP is an unregistered security, while vastly more token holders worldwide claim that it is not. Just added to our document library, order granting John Dayton on admission pro hacks, vice representing XRP holders in U.S. District Court for Northern District of K in Ripple Labs into litigation. Link to order. Fred Rispoli, Also, an attorney from the community commented on Deaton's move with applause, saying, "Being familiar with class actions, the class certification battle is the most important fight in these types of cases. John coming in here in this capacity is a real kick in the balls top." Plaintiff's counsel, and I don't disagree with John, but the ball kick cannot be overstated. For his part, Deaton commented on Filan's announcement on Twitter, saying, "Whether it's the SEC or a plaintiff's attorney making the absurd argument that secondary market transactions of a token are also securities simply be it may have been previously offered or sold in a way that violated Section 5 of the Securities Act, I'll see you in court."